No doubt, every day I saw the challenges that SMEs and micro enterprises experienced in trying to comply. There is less scope for limiting the application of certain obligations by organisation size. I do think that risk-based approach in the GDPR is correct because you can have risks to individuals' rights and freedoms, no doubt.
Welcome to Privacy in Practice, the podcast where we bring you the latest insights, practical solutions, and real-world stories from the world of data protection and privacy. I'm Kellie Preez.
And I'm Danie Strachan. Privacy in Practice is brought to you by VeriSafe, your trusted partner in privacy and data protection. In this podcast, we dig into the challenges and opportunities in privacy compliance, from navigating complex regulations to building a sustainable privacy program that works for your business, not against it.
So let's jump in and get practical with privacy.
Our guest today has been called the world's first global privacy regulator and a paragon of judicious, balanced, disciplined, and principled enforcement and regulation. Today, we are truly thrilled and excited to welcome Helen Dixon to the podcast.
Helen most recently served as Ireland's Commissioner for Communications Regulation. Prior to that, she was the Irish Data Protection Commissioner and oversaw several landmark cases, including the high-profile Schrems litigation and rulings against prominent companies such as Meta and investigations into Twitter, TikTok, Apple, and others. Her office levied over €3 billion worth of fines for GDPR violations and, in some cases more critically, important corrective actions against some of the world's largest tech companies to direct and protect their processing of EU user data.
Helen's 10 years at the helm of the Irish Data Protection Commission spanned many eras in data protection, starting in a largely remote and small DPC to riding the waves of GDPR implementation and ultimately leaving a powerhouse office of several hundred staff strong. She is undeniably one of the most interesting people to speak with about EU privacy regulation in today's fast-paced world of change, and we are absolutely thrilled to be able to speak with her today. Welcome, Helen.
Thank you. Absolutely delighted to be here. Good to be talking about the GDPR again.
Thanks so much for joining us, Helen. It's actually a real privilege for us. On your LinkedIn bio, currently it describes your role as listening and learning. We really love that description. What does it mean?
Oh gosh, it probably should be listening and learning and still making lots of mistakes. But what it actually refers to is I stepped down at the end of February from my role as Commissioner for Communications Regulation in Ireland. And I stepped down because I'd been 18 years in regulatory roles and I felt the need to take a new perspective on some of the challenges that no doubt we're going to be talking about today. But because of that very senior set of public sector roles that I had in Ireland, I'm essentially in a cooling off period for 12 months under our standards in public office. So basically that prevention of revolving door type phenomenon. So in order in the first 12 months after I finish up to take up any contract or employment, I would need to go through a series of approvals and consents. I have opted not for the purposes of taking up any work in the area of data protection or digital regulation to go through that process because I think appropriately the restrictions that would be applied to me in this early period would simply be considerable. I have, however, and I notice it's just been announced today in Ireland, made an application to join the board of an environmental organisation, an environmental company, as an independent non-executive director. And it's a company called Repack here in Ireland, and it leads in promotion of circular economy and in the area of packaging waste. And so it's hugely interesting now for me to be involved in an oversight role in a new area that's heavily regulated and where new EU regulations in the form of a packaging and packaging waste regulation are coming on stream now. So I'm really looking forward to contributing there. I do expect, though, on the 1st of March, when the 12 months cooling off is up, that I will work again in some shape or form in the area of data protection and digital regulation. So that's what listening and learning means. I'm really absorbing new perspectives.
I can't help but mention this now because I can see a connection between repackaging and data protection. There was a recent fine, I can't remember in which country it was, but a company was supposed to destroy a hospital's records. And they found that they've sold or that they provided the records to a restaurant and they used it to package the takeaway meals. So some people opened up their wraps or whatever they might have been and they had someone's blood test results or something on there. So there is a link between data protection and repackaging, it seems, but I think anonymization is also very important.
There surely is, but I suspect what you're alluding to there is there's a link between data protection and almost everything. Any human activity, any economic activity, any social activity, there's a link to data protection.
That is actually probably a good segue from the small business wrapping things to the point about all businesses involving data protection. I know you are famous for lots of things involving big tech and big enforcement actions. But on this podcast, we'd like to really focus in on sort of smaller, medium-sized companies, not necessarily the teeny tiny sort of mom and pop shops that might have limited privacy issues around, say, I was going to say CCTV, but let's say, packaging of food with people's blood test results. But let's say sort of that 50 to 500, 1,000 employee mark company that's kind of growing. That's kind of a really interesting space to navigate balancing data protection requirements and growth. I understand that one of your very first roles was working for an American company as it was trying to grow, probably a similar employee count size, at least in Ireland. Can you talk a little bit about that and whether that gave you a sense of some of the hard choices companies need to make as they grow around balancing that with compliance?
Yeah, I'll certainly talk about that. I'm not sure how illustrative it is, and I'll talk maybe about a more recent example. I worked for a US multinational, actually 2 US multinationals in the first 11 years of my career, but the one you're referencing was a publicly listed company that was working in the early 2000s towards becoming a $1 billion turnover company. So it was expanding rapidly in locations and in size, and including in its Irish operations. Significantly, when I was there, Sarbanes-Oxley rules came in, and I can recall that there weren't any hard choices in that company about compliance. All of us were drilled. It wasn't just the financial controllers team on corporate governance requirements and what Sarbanes-Oxley meant in terms of a publicly listed company. Also around that time, there were a lot of sexual harassment cases, particularly in the US, in companies, and that company invested so much in training to make sure all of us weren't just compliant, but we understood the purpose of why these rules existed. So I think in that sense, it's not a company that really taught me anything about hard choices because it leaned into compliance as if there was nothing of greater priority. But also, I think because that was early 2000s, there was a lot less regulation. Sarbanes-Oxley we talked about all the time, but there's now so much more regulation and digital regulation that would apply to that company. I think maybe illustrative for me in terms of the question that you posed about those sort of SME size type organizations is even the last year that I spent in a regulatory organization in Ireland, but one which wasn't specializing in data protection. And even in that year that I spent there, issues arising over use of swipe card data to inform desk sharing policies, uses of CCTV, issues arising in that crossover between communications regulation and how you cut out spam messaging and fraudulent calls that necessarily then start cutting across data protection and privacy issues. So much was arising on a weekly basis in that organization that it gave me real insights into how challenging it is outside the bubble of data protection that I suspect all three of us live in. Even when you have professionals, legal and technical, that are well trained in every sense, when you're not living and breathing the case law that we love to lap up every day, it's a little bit more challenging.
You mentioned being excited to chat about the GDPR again. One thing that we find fantastic about the GDPR is how flexible it is. It's more principles based. It doesn't prescribe specific technologies or specific solutions that have to be used for something, but it's also very organizational neutral to a very large extent, which can sometimes create challenges for small and medium-sized companies. Circling back to the discussion now on big tech companies, I think many organizations feel that it's a very heavy burden to comply with the GDPR. There's already so much else that they have to focus on, so many other compliance requirements. Do you think there's any flexibility for compliance based on size of company or type of data processing? So there are the recent proposals surrounding simplification of the GDPR, and there are some carve-outs for smaller organizations. But any thoughts about that? If there is a way to approach the GDPR in a more flexible way so that it's easier for smaller and medium-sized organizations to comply?
Yeah, I think with that simplification agenda that you're referring to, it is a good time to revisit those questions. And no doubt, every day I saw the challenges that SMEs and micro enterprises experienced in trying to comply. I'm inclined to think, I don't know what you think, that there is less scope for limiting the application of certain obligations by organization size. I do think that risk-based approach in the GDPR is correct, because you can have risks to individuals' rights and freedoms, no doubt, and I can cite some examples that arise no matter what the size of the organization. Take a small diagnostics imaging company. If they don't have secure processes and procedures for when individuals are logging back in to look at their MRI scan and they're gaining access to other scans, or the data can easily be exfiltrated by third parties, the risks are considerable there. There were a couple of cases early on in the application of the GDPR that I and my office investigated involving a public sector body in Ireland. It was the Child and Family Agency called TUSLA in Ireland. But it was an illustration of how even with an organisation of a relatively limited size in the scheme of what we're talking about, real risks and damage can arise. So in cases that we looked at there, vulnerable individuals that had been subject to abuse and even potentially violence, their location details were then shared with exactly the person that they shouldn't have been shared with through a failure in redaction when documents were disclosed on foot of court order and access request. So those kinds of issues can arise no matter what the size of organization. I think there's still lots that can be done to help SMEs. And I think more can be done in terms of tools. I see now there are tools that are coming on stream that help small companies look at what kind of cookies their websites are loading onto users' devices and so on. But I think we could have more tools and assistance for SMEs in terms of some of the basic things that all of them have to do. Subject access requests, as all of you know, is probably one of the biggest challenges that SMEs and any organization faces. And it mightn't even be by volume. Sometimes the organizations that have to deal with them at high volume, they can set up levels of automation and systems and get into a flow, I suppose. It's the SME that deals once a year with an aggrieved employee who's now going after something that they think is on record in an organization that can really struggle. So I think there is more that can be done in terms of consolidated guidance that assist organizations in navigating those tricky areas about the exemptions that can be applied in terms of data that's disclosed, in terms of what a proportionate search is, because even in that employee context I mentioned where, you can have an awful lot of email data aside from anything else on file, there's a huge amount in it. And I think over time we need better illustrated case studies that can help SMEs comply. So, long way of answering the question, I see less scope by organisation size, but more scope nonetheless to help. I think just to add, the other thing I would say is, and it's easier said than done, of course, for SMEs, often the application of fairness and common sense can bring you a long way in dealing with scenarios. And we've all walked ourselves into it, but as a regulator, I often saw how an SME just made its life so much harder because it was trying to restrict, it was trying to delay, it was trying to not accept what the obligations on it were. And sometimes I think just applying fairness and common sense and dealing with the straight bat can serve us all better in the end.
So true. I'm actually thinking of a project I'm working on with the client at the moment, and they've received a couple of data subject requests, and they've been trying to evaluate should they or should they not apply to this, where is this person based? And I just reminded them data subjects are also customers. You want to keep your customer happy. If you can just respond to that query and just give them a quick answer and just get rid of it, you're going to save everyone time and effort and keep the customer and the data subject happy. So often compliance does align with business sense, but it is a tough call. You have to evaluate the kind of request carefully.
Yeah, absolutely. You remind me of a case I dealt with that just didn't have a satisfactory ending. From anyone's point of view, it was a complaint from a couple who had a very young baby that they placed in a creche or a nursery, and they collected him one evening and they said he was like a different baby. He had a big angry red head. He was upset. He was not himself. And the creche admitted that there'd been some form of incident during the day, but it was a little bit vague. So the couple put in an access request and they asked for video recordings. There were cameras in the rooms. And they specified what camera they wanted pointing into the room where the child was. They got the footage, and when they got it, they realized that the camera they'd asked for wasn't quite at the right angle. It was actually showing the back of the baby and not the third party he was interacting with. And it was a different camera they needed. And of course, when they went back to the creche, they'd auto-deleted the other footage. And the couple was very aggrieved. They took their child out of the creche and wanted me to enforce against the creche on the basis that they would have known that really what they were looking for was footage of the incident, and auto-deleting the footage of the other camera was unacceptable. I didn't pursue it. I didn't think I could prove that they'd done it deliberately. But I think it goes to some of the points that you've made there, Danie, that doing the right thing, I think, would have been easier in that case and served everyone better.
I think one thing I'm struck by in your answer as well, Helen, going back to the first part of it, is we can't say that certain parts of the GDPR don't apply, but perhaps it's that proportionality test or it's the security measures in the imaging company, right? I mean, Article 32 says you can take into account a lot of things, state of the art, cost of implementation, risks to rights and freedoms, things like that. And so I think what I, though, am struck by is that's wonderful. That flexibility is wonderful. And I think it's not always successfully deployed as much as it could be in terms of, as you say, fairness and common sense. But I also think that fundamental in all of that is a deep understanding of what data you process, where you process it, whether it's sensitive, where it comes from. And sometimes I find that is one of the biggest compliance costs, constantly knowing that, updating it. And maybe to your point, that's what we need to design better systems for or have better guidance for. But I think that very frequently that is the crux of the compliance problem.
Oh, absolutely, I would agree. You talk to a lot of organizations that dive in talking about a data protection issue, and then when you try to step back and say, what kind of IT estate do you have? What kind of data do you hold? What kind of employees, clients, third parties, suppliers do you deal with? Do you transfer data out of the jurisdiction? What are the critical business functions that you have that use data? Do you need all the data? What kind of websites, portals that provide public access do you have? Often very senior people in an organization, and I know it myself from going into a new organization, it can be very difficult to uncover that, but it is foundational in terms of starting to understand what is the business we're in, what have we got, and what are the risks applicable to the personal data processing. And then on top of that, you mentioned, Kellie, the CCTV earlier. It's surprising how often, even with big multinationals in regulating them. The complaints we dealt with were about employees or third parties relating to physical security measures implemented by organizations. So that one, I wouldn't dismiss it as a triviality in terms of data protection compliance. It's a banana skin that comes up surprisingly often.
We have a team member that's going to be really happy to hear that. He's constantly pushing us to come back to physical security reviews.
Very good. I mean, I do notice there does seem to be an increasing prevalence of employee surveillance, if you want to call it that, biometric scanning entry systems and access systems, and as well as the more traditional CCTV and camera-based. So it is an area I think to keep an eye on.
And people actually forget about paper. I had a conversation with a client via email yesterday because almost everything they do is online, but sometimes a form must be printed and filled in and it gets scanned. But this is being done by a service provider. And I immediately started worrying because what happens to that form once it's been completed? Because I care about where the image goes and where that's filed electronically. But what happens to that piece of paper, especially if you have a contractor that works from home or somewhere? Do they have a shredder? Does it just end up in the dustbin? And unfortunately, people often forget those basic things. Maybe they're not the biggest risks, but they do lead to breaches.
Yeah, because it can be the small things. I think that is a good point because SMEs could also do with more help around how do you demonstrate compliance. Perhaps I think I should keep the paper forms because then I can prove Danie consent. But actually, once I've recorded the consent, really I don't need to keep the form, arguably. So I think there are lots of questions like that where organizations struggle with what do I need to demonstrate compliance with legal basis requirements, particularly consent, and what can I then dispose of. I think organizations are getting better at it, and I've seen, when in doubt, record the consent and dispose of the documentary evidence.
This might be a very difficult or even an impossible question, but if you were a growing company, or if you were working at a growing company of, let's say, about 100 employees with a privacy compliance budget of 100,000 euros or dollars, what would you tackle first? Where do you start?
That's a decent chunk. Right, I'll assume I'm in the small company that with 7 years of application of GDPR and other jurisdictional laws that I've done a fair bit of work on some of the issues Kellie and I were talking about earlier. So I think I'll start by using the 100,000 to bring in a third party to perhaps go back over some of what I've done and to refresh and look at it. And I'd start with what Kellie and I were discussing earlier. I'd go back and look at what really is the business area that we're in, or what are the business functions? What is the data that supports that? What kind of personal data does the organization hold? In what categories does it sit? Is there legacy data that actually is being held just in case that's no longer required? How is it secured? How is it stored? What kind of jurisdictional issues, if any, arise with it? Once I would have gone back over that with a third party and identified any gaps that would need addressing, then I think it is the risk assessment. Going back and looking again at what are the areas of risk by reference to newer case studies and case law that have arisen. Are the particular risks with the public-facing websites and cookies? We see the French Data Protection Authority imposing a lot of fines for failure to comply with the basics under e-privacy. Is that a particular area of exposure? Or is it around data transfers? Are we as up to date as we need to be in terms of safeguards that are applied and documentation around transfers of data? Then I think, having completed the risk assessment, it would be time to review all of the documentation, the internal documented policies and procedures, internal templates used, for example, to acknowledge and respond to data subject rights exercise, in particular access requests. Sometimes I find when you go back and read the templates you designed a year ago, the language isn't quite right and perhaps giving hostages. So go back and look at all the templates that staff are routinely deploying. Look at the public-facing privacy policies and notices Are all of those things correct and good? Look at some of the peripherals that I was talking about earlier. Company, do we run events? Have we got our processes and procedures around events and photographing people and distributing names and email addresses of delegates? Again, these seem quite trivial in terms of fundamental rights and freedoms, but they can trip you up in terms of some people's perception of what interferes with their privacy rights. Then I think if budget remained, I would certainly go back and look at refreshing training for staff. Can all staff recognise, particularly the HR department, a subject access request? Can they respond appropriately so that they don't irritate and aggravate a situation and equally not comply with the GDPR? Do staff really understand the purpose of the GDPR? Can they be a little bit more inspired to comply rather than seeing it as a very awkward burden? Maybe bring in an external speaker that will really enliven it. If there's a board in the company that I'm a member of, maybe do a little bit of a refresh for the board in terms of its oversight role about what it might want to keep an eye on. So yeah, I think I'd bring in a third party and do a full A to Z refresh and review would never do any harm.
Let's say conversely, it's a early stage company, so you're a young company, not a lot of privacy compliance work behind you yet. Budget isn't a challenge, but time is the challenge, because often we find, even with some of our clients, the person in charge of privacy is actually in IT or somewhere else, and they have a full-time day job and they might only have 5 to 10 hours a week to handle the privacy issues. How do you address that if there is a way to?
Well, then I think what I would do is I would complete that gap analysis, do all of the steps we talk about, complete a gap analysis, and there will be a gap analysis in a small stage, and there will be not so much nice to do, but not a priority to do right now. And so I would focus on an action list of things that need to be done now and need to be set up so that as they're done right from the beginning, and then pick off based on whatever time I have. For example, I mentioned templates a few moments ago. Perhaps it won't be the most urgent thing, first of all, to start creating the repeat templates. That can be a later on action. But it will be a priority to itemize what kind of data is there by reference to the business and conduct that kind of risk assessment on it.
That's great advice. I think that's a great approach you've suggested there.
And I always have had a lot of empathy for data protection officers, and I know with the Irish Data Protection Commission, we always have had a focus on trying, there's more that can be done, but trying to support data protection officers in organizations, because it's not easy and the judgment calls aren't easy, and the resilience in the face of sort of resistance and attitude can wear you down as well.
Do you have some foundational guidance or quick tips for organizations when it comes to handling data subject requests? So, for example, I think there's often a tension between merely just answering the question and not giving anything else. So the subject is asking, do you have my data? And some organizations would say yes and kind regards. Others would say yes, and this is what we do with it, and this is whom we share it with. And then they open the whole Pandora's box because suddenly they realize that it's actually sitting with a partner, and now they have to explain that to the data subject. How do you approach that? Because I think some organizations handle this almost like pre-litigation. So you're very careful when you respond, making sure you're not putting something in that email that could end up somewhere on a regulator's desk, while other organizations feel, let's be more cooperative and try and help this data subject because they are concerned about their privacy. Any tips, anything that you've seen from your experience that might help organizations to just get the right mindset and sort of some foundational guidance?
Yeah, maybe what I would say is sometimes approaching it with a little bit less emotion when you know it's coming off the back of a grievance, but perhaps approaching it with a little bit less emotion and not spending too much energy on what the motivated reason you believe for the access request is, accepting that the individual has a right. Generally, advice that I would give around dealing with an access request is not to be afraid of, and in fact, I'd encourage engaging with the data subject. Of course, the request may have come in writing, but if you can make contact to try and understand what are they really looking for, because if you assume reasonableness on the part of the person who's putting in the request, sometimes they've a very specific thing that they are going after for a specific purpose. And if you understand that, then you're likely to be able to limit your search and what you provide them with a copy of their personal data in a way that satisfies them. I think engagement with a data subject can assist all parties. If it's a subject access request, then for a copy of personal data where the files it is stored in are extensive and considerable, and it may even be one where it's legitimate to charge some fee, where it's going to be a considerable amount of work, then I think absolutely engagement is required. Typically, as a controller, you're going to have to convey that you're not going to be fulfilling it all within 30 days. You're going to be setting out a process by which it's going to be fulfilled. And I think getting a strategic plan around what a proportionate search is going to involve and communicating that and involving the data subject in it. Look, these are incredibly difficult, and because they often arise in very contested circumstances, they are hard to do right. But definitely, I think looking at some of the case studies, organizations can extract themselves lessons on what will make it easier in the long run.
I'm struck by, again, the common sense and the fairness. There's lots of stories in the US outside of the data privacy context where, someone sues a doctor, someone sues a hospital. I'm thinking again about the case you mentioned with the child in the creche. Ultimately, what the family wants is an apology and a donation to the charity, or something like that. It's very good advice. And I think, as Danie says, especially when you have that pre-litigation hat on, often nobody wins.
Yeah, if you can bring it back to a human level, sometimes it flows quite well, because a lot of requests are reasonably constituted and have a genuine purpose. So I guess being cynical and suspicious always doesn't serve us well.
Any other common mistakes, especially for these SME type companies? Anything else you saw in your role as a data protection commissioner that you were just like, oh, guys, why were you doing that? What were you thinking?
Definitely lots of common mistakes. On the security side, often a failure putting out basic systems to test the systems properly before they're put out, before they're put into production. We had cases in Ireland with our central credit register where it was put into production and essentially it was failing to correctly record when individuals had paid off loans. And so it was recording them as being in deficit and affecting their credit ratings, which is obviously a hugely serious impact on an individual's rights by reference to their personal data. Other cases involving banks, incredibly, where electronic banking systems were launched, where there were issues around connected individuals that at one point might have had a joint account that now no longer did, but where they could still access the other's accounts. Often we found with banks and telcos and those kind of industries where you often have mergers, where there's legacy IT systems merging and the handoffs aren't quite right, you get those kinds of issues arising. Another thing that we saw frequently enough in my time at the Data Protection Commission was very good documentation and processes and procedures, and then a failure to comply with them in practice. So, for example, I'm thinking of a complaint that I dealt with. I don't know if this phenomenon exists in your jurisdiction, but in Ireland, a lot of people in generations of a family can have the same name. So you can have Thomas O'Brien and Thomas O'Brien Jr. and little Thomas O'Brien Jr. In a particular case we dealt with, an individual had called a bank seeking access to information about an account on the telephone. It was the wife of a couple. They had a joint account together to which they both had access. but there was also an account in the name of their son that had the same name as the husband. Essentially, the mother gained access to the son's account because they took her as being entitled to that access by reference to the joint access she had to an account in the name of her husband who had the same name as her son. And that was a failure to follow policies and procedures around verifying identity and so on. And we saw it with telcos as well. Other issues arising were simply that classic issue of, on big things, perhaps the organization thinks about GDPR and data protection impact assessments, but then they do something like decide, it would be good to scan every employee coming in and out all day long. And perhaps there's no issue with it from a GDPR sense, but they won't have done the analysis to establish that. And the Data Protection Authority gets wind because suddenly there are complainants from that company saying our company has overnight introduced XYZ system, blah, blah, blah. So it's that failure to even think there are data protection potentially implications here. In some of the SMEs, particularly maybe at the larger end, where they're straddling being very manual still with dealing with data subject rights and automating to some extent. They might have email addresses that you can direct your access request to, but in fact, they're not manning them and they're not really looking at them as frequently as they should. If you're setting up a system to deal with things, then make sure you're appropriately monitoring your own system.
Interesting that you mention names. I think that sounds trivial, but it can lead to serious consequences. There was a ruling in Spain earlier this year where a company got fined more than €1 million because they opened an account for someone who never requested the account. And it turned out that it was the same name. So they just assumed that this is the person and they opened the account for them and they had 2 customers with the identical names. And obviously they didn't do sufficient checks to check who is this person requesting the new account. And obviously the person was very aggrieved, but that led to more than €1 million. So sometimes it can be a serious issue if you're not taking names seriously.
Basic procedures that are the procedures necessary to validate who you're talking to. Yeah.
Fun fact, my mother-in-law and I have the same name, and we live in a very small town with 1 doctor and 1 pharmacist. Another thing that I think a lot of our company clients struggle with is the e-privacy piece. And I'm sure there's many sort of mistakes there, particularly because I think when it comes to things like vendor selection, so many of the vendors they want to use are in the US. And then you have all these recent cases, like the one from that administrative court in Hamburg recently about Google particularly, but I think it's like the principles are sound for other sort of US entities as well. I think one pitfall potentially is thinking that because you have picked a trusted vendor or a vetted vendor, it's just it's the way you are using them that potentially people need to examine. But I wonder if you have any advice for people, especially American companies trying to move into the EU. It's a very different set of rules around the e-privacy space. Any advice or pitfalls you've seen there?
And some of my advice would be watch this space, because we know in legislative terms that the EU Commission has been looking at reforming e-privacy for the last 8 years, and now they've withdrawn that e-privacy regulation proposal. But it is going to be dealt with, we think, in this omnibus law. There is going to be something forthcoming in terms of streamlining of the rules. I think you're absolutely right. It's the configuration of the CMP, the consent management platforms, that is often at issue rather than the consent management platforms themselves. So that's something to watch out for if you're using a third party to do that systems implementation for you, that you oversee it to make sure that it's going to be compliant. I think probably advice that I would have would be really to look at the European Data Protection Board's report from 2023, I think it was, on a series of cookies cases. And that probably has sort of a basic benchmark and cross-section of the major issues that companies need to pay attention to. In particular, is that guideline now to include a reject all button as easily as the accept all button on the first screen that the user sees. But it's an area that's not quite satisfactory, and I think the EU will make moves to streamline it.
Is there any kind of approach when it comes to the configuration of the banner? Because I think many US organizations struggle with this, or maybe they shouldn't, because you also have disparate state privacy laws in the US. But when it comes to the EU, specifically cookies compliance, it seems that each data protection authority in Europe has their own thing that they're focusing on. Should you disclose the list of cookies, etc., etc.? How do you approach that? Because let's say you have data subjects in around 10 of the EU member states. Is it possible to even try and comply with the particular requirements for each jurisdiction, or do you just go for the gold standard?
Yeah, and I'm not even sure you'd be able to distill a gold standard. As you know, the e-privacy law is in the form of a directive, and so there is considerable fragmentation. It was implemented in national laws in the member states in surprisingly varied ways. And it has territorial applications, so there is no one-stop shop in it, no country of origin where you can use the location of your HQ as the standard by which you'll implement. So at the moment, and this has been some of the grief with it, the laws do vary considerably in the detail in the member states, and depending on what interests you have, you are likely to have to invest in local compliance measures by reference to the websites you're offering in the different member states. As I said, the EDPB has some of the cross-sectional basic issues, but depending on what you're doing, there is going to be detail you'll need to be across.
Something that has come up more than once recently is pixels and cookies, specifically in relation to emails. So tracking pixels in emails, because I think many organizations focus so much on their consent banners. But then, especially if you're in e-commerce or in the big B2C space, you'll send lots of emails out and you want to see, do people read them? Do they delete them? What do they do next once they've clicked on the email? The French authority issued draft guidance recently. I think it was for comment. Very serious guidance, I think, because many organizations don't necessarily disclose in their emails that they use tracking pixels. I don't know if they give individuals options to switch those pixels off. If in Europe, you need to get consent for those pixels. How do you do that? I'm not sure if that's ever come up, or if you have any thoughts on that, because it looks like that is now the new frontier. Never mind, cookie banner is still not being sorted out yet.
Yeah, I think what I would say in a general sense is I would pay attention to that guidance from the CNIL, because clearly the French authority is putting its money where its mouth is in terms of enforcement of its e-privacy laws. And we saw that very recent significant fine that they imposed against Google and Shein. Google in terms of advertising inserted in between emails. So I think it's probably instructive to look at the decision they made in that case as well and pay attention to the guidance. Pending a review of all of this, which we believe is in the offing at EU level, but I think for the moment the rules are stringent.
So as the resident American here, it's funny you mentioned SOX, the Sarbanes-Oxley stuff. That was my sort of beginning younger lawyer stage was securities regulation and securities litigation. And I think that my experience dealing with financial regulations, SOX, and other laws in that space is that regulators are not only not lenient, if you will, about attempts to comply, they also are sort of looking for blood in the water, if you will. Like they are looking for that one part of the spreadsheet that's wrong. So it's not just, oh, you have a spreadsheet, you tried. Like that's definitely not true. It's also, of the 4,000 rows and columns, 3,098 were fine and 2 were clearly non-compliant, and therefore we've got a whole case against you. And I wonder to what extent you think that's sort of a US problem, or how your office would approach that. Let's say somebody gave you a risk register, and that risk register included 5 known gaps in GDPR compliance. Would you consider that better than no risk register at all? Would it matter how they talked about the risks? Would it matter what decisions they made about those risks?
I'm going to give you a very serious answer to that question, because in fact, I spoke yesterday, and I'll try to be concise, at an interesting conference in Dublin. It was a data protection conference focused on privacy-enhancing technologies. But some of what I spoke about in the keynote that I gave was the fact that the GDPR doesn't really set out any prioritization method. It's a law that requires data protection authorities to handle every individual complaint of over 400 million EU persons. As Danie was talking about earlier, it doesn't set out any prioritization by organization type, really, or size. It has a very general risk-based approach. And its objective in Recital 4 is to ensure that the design of processing of personal data serves mankind. So it's very wide open with huge volumes of complaints and then big systemic issues being highlighted coming at data protection authorities. How do you adopt an approach which isn't set out in the GDPR to responsive regulation? How do you build capacity at the bottom and then make sure you're just sanctioning at the top, when in fact what the GDPR says is that you investigate every issue, and if you find infringements, you impose corrective measures and give consideration to imposing a fine in every case. And of course, in reality, as a data protection authority, particularly in a common law jurisdiction like Ireland, if in response to every single case where a controller does not comply with the subject access request within the 30 days, you sought to sanction and impose a fine, you would just tie up all of your resources in court cases and administration. And I wonder, what would be the theory of change there? Would you be achieving a change in behavior? So in reality, to answer your question and come back at it then, the reality is that whether it's stated in the GDPR or not, in practice, how compliant and cooperative and course-correcting an organization is as you're dealing with them does count. Particularly if you're dealing with a once-off complaint, the organization has not come to our attention for any other reason, and it's one or two individual complaints. Then if you can see that the organization has made an honest mistake or just got something wrong, did the analysis but really went the wrong fork in the route, you're going to simply get satisfaction for the data subject and move on and try and focus on the bigger systemic risk, the repeat offenders, the issues where simply an organization simply had to have known better, that they had not implemented any level of state-of-the-art, for example, by reference to the risks that they must have known were inherent. So informally, yes, is my answer to your question. As to whether the GDPR provides for that, I don't think so. And it's probably not ideal.
Kellie talked about a risk register. Is it something that you'd like to see as a regulator? How much focus should organizations put on recording all these potential risks and what they're doing, breach registers aside?
I think a risk register is a very, very good thing, because once you've understood your business, what data you hold, what uses and purposes you have for it and how you're processing it, think and look at the risks, then I think you do want to document it. By knowing you need to document it, it forces you into doing the thinking about it. So sometimes I think that's what the benefit of it is. People talk about these things shouldn't be tick boxes. Absolutely they shouldn't, but perhaps by having to tick a box, it forces you into sitting around and engaging the principals in your organization about what really are the risks here and what's the nature of the risks. Are they reputational? Are they to the organization as well as risk to the rights and freedoms of individuals? Are they very heavy cybersecurity type risks by reference to the nature of the sector that we're in? Risk registers, I think, are a good thing, and the documenting serves a purpose.
Is there anything that US companies should know about interacting with EU regulators? Because I think in the US, it's very serious. If there's a letter from any kind of authority, organizations are very careful and the lawyers are on board because it could end up being a big thing. Is it the same in the EU? Is there any difference in approach? I'm not sure if this is even a fair question, but is there something that they should know? Is there a different culture?
Yeah, well, I think beyond culture, there are different functions that data protection authorities have as compared to, say, the FTC and other types of organizations in the US. So it's clear in the GDPR that data protection authorities have a role in issuing guidance and ensuring that there's awareness. So in that sense, often you can't develop guidance in isolation without consultation with not just industry, but the public sector bodies and the other types of organizations. So that forces an engagement. And even at the EU level, where we're looking to try and harmonize more, we see that the European Data Protection Board over time began to have face-to-face consultation events involving representative bodies in terms of some of the big guidance that it would intend to output. So I think there is engagement and there's more engagement. You're perhaps talking about less the general sense of engaging and more a complaint or there's a breach that has been notified. I think there is a level of formality that comes with that, but also there's clearly an intention to be fair as a regulator and to be open and transparent and listening to submissions of an organization, however they are made. If it's an isolated encounter with the regulator on a subject access request, then I think there should be no fear of the engagement around, look, what is the data subject looking for? How can we get that to them? Certainly the Data Protection Commission in Ireland and other authorities would look to use informal and amicable resolution where it makes proportionate sense, and that's to the benefit of an organisation. And the better they engage at that informal level in a process, the quicker and easier the issue can be put to bed and everyone moves on.
I think it's all about approach and being pragmatic. As you said in the beginning, it's about respecting data subject rights and just trying to get to a solution. Obviously, you shouldn't do something that will harm the organization in the process, so you have to look after its bank account. But when it is practical, just try and work with the data subject instead of against them.
Common sense and fairness. Again, it's a good catchphrase, common sense and fairness. Helen, now that you've left the world of regulation, at least temporarily, perhaps, is there anything that you, now looking back, feel you would have approached differently, or have your views changed sort of now as compared to perhaps when you started about some of these issues?
As I said at the beginning, having stepped out, and Danie asked me about listening and learning, I think sort of gaining perspective is always a very positive thing. So I would say there are some things, maybe lots of points of detail looking back that I would do differently. But maybe the big thing, if I look back now, is that I might have liked to have spent more time trying to lead out on conversations that engage the broader public around their perception of a lot of these issues in the digital age. We see a lot of tension now between the issues of safety and privacy, safety and data protection, security in even a national security sense, physical security and data protection. We can analyze the law. We know that social norms and the perception of the public in a broader sense of where the balance lies is important in concluding on all these issues. I'd like to have had an opportunity to spend more time leading and contributing to those kinds of conversations at a broader level. In reality, of course, my time was spent in the detail and the weeds of very, very large-scale investigations and procedural wrangling and sometimes political wrangling about Ireland and the DPC's place in the EU orders. So that's maybe one thing. But look, you'll always look back, want to do some things and want to do more.
Yeah, the hindsight is always 20/20, isn't it?
Helen, thank you so much for your time and for all your insights. It's been so lovely to talk to you. It's been such a privilege.
Pleasure's been all mine. Thanks a lot, Kellie and Danie.
Thanks so much, Helen. And I hope that our paths cross again very soon.
That's it for today's episode of Privacy in Practice, brought to you by VeraSafe.
If you enjoyed today's conversation, be sure to subscribe so you don't miss out on future episodes. And we'd love to hear from you. Send us an email to podcast@verasafe.com.
And to learn more about VeraSafe's data protection and privacy services, you can visit us at verasafe.com.